One marijuana gummy every other night. That's it. And the federal government says you can lose your gun rights. Don't take my word for it. Listen.
What if he took one gummy bear with a medical prescription in Colorado? You don't even need that anymore. But let's say he had one to help him sleep every other day. Disarm him for life?
Well, no, it's not disarm for life, and here's what's going
Potentially.
on. Well,
would that be enough under your theory? One gummy bear every other night with a medical prescription.
So I think you'd have a potential rehafe problem, but I will accept the hypothetical. So let me just deal with
I think
what's
the answer
an unlawful
is yes
user.
under the government's theory?
Yes, under our theory, but let me give you
Yes, under our theory, that qualifies. That's the United States government arguing before the Supreme Court. This is United States v. Hemani. It challenges 18 U.S.C. 922 G3 passed in 1968. It says if you're an unlawful user of a controlled substance, you can't possess a firearm. Felony, up to 15 years in prison. That's what we're talking about. Now listen to how they justify it.
Unlike alcohol, illegal drugs are illegal. They're illegal because Congress deemed their use dangerous at any level.
Dangerous at any level. Not dangerous with a gun, not dangerous while committing a crime. Dangerous at any level. So Congress labels something illegal, and that automatically makes you too dangerous to exercise a constitutional right. That's the theory. Now it gets clear.
Our position is Congress made a judgment in 922 G3 itself that it is in fact dangerous to mix firearms with habitual use or addiction to controlled substances.
Congress made a judgment, not a jury, not a court, Congress. And that judgment alone strips the right. No individualized finding, no proof you misused the firearm, no proof you're violent, just status. And here's the cleanest admission.
That way, and
but
I
that
think
would be your backup position. Your primary position is if it's scheduled in any way, so long as you use a couple of times a week, you're subject to disarmament.
That is our position, and because of the combined effects.
A couple of times a week. That's it. That's the threshold. Use marijuana twice a week, you're subject to disarmament. That should bother you even if you hate marijuana, which I personally do. Because this isn't about weed. It's about categories. Now, here's where it gets uncomfortable for the government. Justice Gorsuch pushed back.
Habitual drunkard, the American Temperance Society back in the day said 8 shots of whiskey a day only made you an occasional drunkard. We have to remember the founding era if you want to invoke the founding era. To be a habitual drunkard, you had to do double that, okay? John Adams took a tankard of hard cider with his breakfast every day. James Madison reportedly drank a pint of whiskey every day. Thomas Jefferson said he wasn't much of a user of alcohol. He only had 3 or 4 glasses of wine a night. Okay? Are they all habitual drunkards who would be properly disarmed for life under your theory?
That's devastating. John Adams drank hard cider every morning. James Madison, the guy who wrote the Second Amendment, reportedly drank a pint of whiskey a day. Thomas Jefferson drank wine daily. So let's apply the government's logic. Habitual intoxication, category, disarmed. Would Madison be disarmed? Would Adams? Would Jefferson? Because that's the historical tradition test under Bruin. And the government doesn't want that comparison. Now listen to what happens when the court suggests requiring real proof of dangerousness.
I think this is all the way down from G1 felons, every single category of felons, even the serial murderer. You would have to be able to second guess. Is that person really dangerous? Is that a good proxy? How many people? What other kinds of offenses?
That's the fear. If courts require actual proof someone is dangerous, the entire framework of categorical gun bans gets exposed because right now it's easier to disarm by label. Felon, unlawful user, prohibited person, category first, rights later. Let's be clear, this isn't a case about someone waving a gun around while being high. It's about whether Congress can define you as dangerous simply because you fall into a legislative box. If frequency alone is enough, if illegality alone is enough, if a congressional judgment alone is enough, then the Second Amendment isn't functioning as a right. It's functioning as a conditional privilege, and the Supreme Court is now deciding how far that logic can go. Pay attention to this case because it won't stop at marijuana. One thing's for certain and 2 things are for sure. Politicians and tech giants don't want gun content to be recommended to you, and we're all fighting this culture war together. Now, you can help do your part by liking, commenting, subscribing to the channel, but most importantly, sharing this video with at least one person. Together, we can stop the suppression of our 2A rights. And don't forget to click the link in the description section of this video for the products that I mentioned in this video.